anyone here on anything else other than the Associated Press matter? Surprisingly short calendar, so glad to hear Mr. Earl Hubbard, and I will call that matter now. And so if we begin with appearances, and we don't have a court reporter, so keep close to your microphone if possible.
Michelle Earl Hubbard for the plaintiffs.
Paul Lawrence for the defendants.
Nicholas Brown for the defense, John.
Gary Alexander for the defendant.
Good morning, everyone. So it looks like we're here with some things agreed, at least an agreed request regarding the certifying the question. My only other question I have for the parties is particularly, I'm assuming, towards Ms. Earl Hubbard. The Supreme Court Commissioner stayed a specified subset of proceedings in this case, and my question is there any reason why we shouldn't just stay these proceedings pending a denial of discretionary review or a decision and mandate from the Supreme Court?
So prior to yesterday's ruling by the Supreme Court, or 2 days ago's ruling, the parties had reached an agreement, as you may have read about in the media, to ask this court to stay proceedings in the trial court pending the appeal. After the court stayed the enforcement of the order, we took that to mean that that was no longer necessary. But yes, plaintiff's position would be that it would not be efficient in order to ask Your Honor to deal with lodging of records, reviewing exemptions, ruling on penalties, that it makes more sense to stay all trial court proceedings as well as all the deadlines, have the appeal proceed, hopefully the court accepts review, and then come back and have that addressed once they've answered the central legal questions.
So other than that issue and the joint motion that I received, is there anything else that the parties want the court to address today? So I will be staying all proceedings in this case. I was somewhat surprised that wasn't requested on January 19th, but now that we are here, I am doing that now. There's no need to do anything else in this case. Additionally, while I agree with the parties that RAP 2.2D doesn't really apply to these circumstances, it would be a round peg, square hole. This is the epitome of a situation where certifying a question to the Supreme Court would be efficient and appropriate, and so I'm happy to grant that request that's been jointly made by the parties. And I don't have a copy of the order that is clean without a stamp on it, but if someone has an order, that would be one that I'd be willing to sign. The form appeared correct, and so no modifications need to be made to that end.
Do you have one? I just printed what you had filed. If you have one, we can use yours.
And I don't believe that a formal order is necessary staying the proceedings. I believe we all understand, and the minutes will reflect that. And of course, if something else happens that we need to do for whatever unforeseeable reason at this point, then the request would simply be to lift that stay for those limited purposes as well. But again, I do not anticipate that that should be necessary here.
And Your Honor, just from plaintiff's perspective, we understood that that meant that all deadlines that would have normally occurred also would be stayed, and that's why you haven't seen motions for attorney's fees and the like, because it's premature until the case is ended.
And I agree. There's nothing else to do at this point, and so nothing else will happen, and all deadlines are stayed. And I've signed the order. Is there anything else I can do for anyone this morning?
No, Your Honor.
Great. Thank you. Thank you very much. Have a good weekend. Is anyone else in this courtroom for anything else? And good morning, Mr. West.
Good morning.
So the court will be in recess. Everyone enjoy your weekends.
Thank you.
Please rise. Court is now in recess.